Okay, I think we're just waiting for a few more people to join. Just give it 30 seconds or so. Okay, we'll make a start now. I know there's still a number of people still to join. So good afternoon, everyone, and welcome to the latest social housing snapshot. I'm glad to say that Estelle and her team have let the regulatory team take over for a webinar. And I'm going to speak to you this afternoon in relation to the proposed RWAB's law, which obviously is on the radar of many social housing providers. So, just a little bit about me. I'm a partner and head of the regulatory team. We deal with a lot of health and safety, environmental, and housing related issues across the team. My colleagues Steph and Amy are currently working with me on a number of cases, including some interesting nuisance cases, which I'm going to refer to in a bit. So what are we going to cover today? Well, we're going to have a look at what we are expecting from the actual final implementation of Awaab's law. So what is the background? What are the time limits that as a social housing provider we're going to be subject to? But also have a look at what other elements or areas there are for redress, what those legal standards are, and then no doubt the bit that's of greater interest is sort of what can you do as an RP to prepare for Awaab's law coming in. So, what's the background? Well, the proposed law is named after Awaab Ishak, who no doubt many of you will have been aware of the background to this. Awaab was a 2-year-old boy who died on the 21st of December 2020. His death was as a direct result of a serious respiratory condition that arose from continued and prolonged exposure to mould that was growing in his flat. Now, this was an issue that actually been raised to the social housing provider, Rochdale Borough-wide Housing, prior to Awaab actually being born. So it had been raised to them in 2017 by the Ishak family, and in essence, they didn't really do a great deal to resolve it. A lot of the concerns raised by the Ishak family were dismissed as lifestyle issues, when in actual fact, and what was later sort of addressed by the coroner in the inquest, was that these were just normal use of a social housing flat. So the mold was arising from things like bathing, drying clothes, showering, etc. But there were issues around the adequacy of ventilation and everything else. Now, their response when these concerns were raised was essentially to tell the Ishak family to paint over the mold. They were recent arrivals in the UK from Sudan. They didn't really understand what the situation was, and in essence, they were badly let down. Now, even after the sort of 3-year period, the housing provider had still failed to take any action to address the mould, and that was still the case when Awaab died. Now, as a result of that, the matter went to an inquest. It was a fairly scathing scenario that was sort of borne out after that. But the outcome was that following the inquest, the Prevention of Future Deaths report was sent to the Department for Levelling Up Housing and Communities, to Michael Gove, to address damp and mould concerns. But in addition, the Ishak family then led quite a high-profile campaign to get a change to the law in order to be able to address these concerns and get more direct action more quickly. That was supported quite heavily by Manchester Evening News and Shelter, and has led to where we are now, multiple reviews and consultations. So what has happened? Well, there has been a change in the law. So Section 42 of the Social Housing Regulation Act 2023 has come in, and that has amended the Landlord and Tenant Act. And what that has done is it's inserted an implied term into social housing tenancies, and at the moment is just social housing tenancies, for the remedying of hazards. And again, I sort of, whilst it's just social housing tenancies, there are changes that are anticipated in the Renters' Rights Bill, which may extend this into private tenancies as well. So, but for the time being, the change of the law is this, and that has provided the framework under which new regulations can be introduced to formalise what is, in essence, um, going to be Awaab's law moving forward. So, the gap that it's really seeking to plug is what has been the current position and up to now, in that under the Homes Fitness for Human Habitation Act, a tenant has a right to have a safe, healthy, and a home that is essentially fit for purpose. But where there are issues, there have not been any set timescales for those repairs to commence, and the duty to actually sort them out has been within a reasonable amount of time, which is very vague and quite open to delay and abuse. So Awaab's law has been proposed to try and plug that gap, but at this stage, there aren't any fixed views as to what it is going to be moving forward, because the fine detail hasn't been resolved and it's still unclear. So many of you may have seen that there was a consultation in January 2024. That does set out the proposed timescales under Awaab's law, but the outcome of that has not yet been published. Now, it sits alongside a number of other changes that will impact on housing and housing issues. There is a review being undertaken into the Housing Health and Safety Rating System, the HHSRS, which sits alongside the proposals in Awaab's law. We're awaiting the new regulations that will actually crystallize all of the detail for Awaab's law. So this is very much a little bit of crystal ball gazing today. But what we are assured by the current government is that when the regulations come in, they will be supported by some sort of specific and hopefully helpful guidance. So what we do know, Angela Rayner has already specified when we expect Awaab's law to come into effect. So it's going to be a phased introduction, with the first phase starting in October 2025. And that will bring into effect issues around social landlords addressing damp and mould issues that present a significant risk of harm to tenants. In addition, it will also bring into effect timescales to affect emergency repairs for all hazards. So that would be all hazards under the HHSRS within a 24-hour period. So that's stage one. Stage two, phase two, it's not got any specific timings, but we're told it will be 2026, and that will bring into effect a number of additional hazards, which will then fall within the fixed timescales for investigating and undertaking repairs. So that will include things like excessive cold, excessive heat, management of falls, structural issues, fire, electrics, explosions, and hygiene. And then phase three will expand again. That will be at some point in 2027. And the intention is that at that point, it will bring in all of the remaining HHSRS hazards. Now, at the moment, there are 29 of those. It's anticipated that under the review, that will reduce to about 21, because some of them will be combined. So there is a link between the proposals under Awaab's law and the HHSRS hazards. So what are we expecting? Well, there's going to be a set timescale for investigation of potential hazards, and that's going to be 14 calendar days. So where a registered provider is made aware of a potential hazard, and that's by whatever means. So that can be either by notification from the tenant, or that the registered provider has identified this hazard themselves. Then they're going to be required to investigate and identify whether a hazard actually exists. The clock runs from the point at which the RP becomes aware. So it's really important that that is logged and recorded, and there'll be a requirement to log and record that. And it requires an investigation, and that investigator must have sufficient skills and experience in order to assess the condition and whether or not something does indeed pose a hazard, and if so, what the extent of that potential hazard is. Now, on the face of it, there's not going to be any requirement for a physical inspection of the property because it recognizes the sort of current technical capabilities, the ability to have Zooms, messages, phone calls, FaceTime things as well. But it's anticipated that there will be a requirement to undertake a physical inspection of a property if the tenant specifically requests it. Now, when looking at the hazard and what the nature of the risk is, the RP is going to have to actually assess the risk to the resident. So there's not going to be a requirement for that resident to provide any medical evidence of a particular condition or something that they are suffering from, which was one of the proposals by the Ishak family as far as their review was concerned. Actually, the government have said, no, that's not necessary, and that's putting too much of a burden on the resident. So it will fall to the RP to assess what that risk is. And this is not just looking at the condition of the property. This is more subjective. This is taking into account any particular vulnerabilities that that resident may have. So somebody who may have COPD or severe asthma, what would be the impact of damp and mold on them compared to somebody who doesn't have any chest problems or any breathing difficulties? So there's a set 14 calendar day timescale to investigate. Following that, then there is a 48-hour period by which the RP has to provide a written summary of their findings and then what is going to be done to rectify the issue. Now, if as a result of that investigation, a very sort of serious issue is identified that would involve significant and imminent risk to the health and safety of the resident, then actually that 48-hour period will be done away with. It will move straight to an emergency repair. If, as a result of that investigation, the RP identifies that a hazard poses significant risk to the health and safety of a tenant, then there is a 7-day period by which repairs have to commence. So that's within 7 days of the written summary being issued. And that requires boots on the ground. So it means that somebody will have to be there, they will have to start work within 7 calendar days of the written summary being issued. It recognizes that there might be some works that need to be done in the interim to make things safer, and there may be a bigger, longer-term problem, structural issue, something affecting the structure of the building, and so it does allow for those wider works to follow. But in essence, as an interim measure, somebody has to be going in and sorting it out. Now, if it's as a result of the investigation, that there is a hazard or there is an issue, but it's not deemed to be a significant risk, then that fixed 7-day timescale will not apply. But it still needs to be repaired, but it can be dealt with as a routine repair. So you have essentially 3 categories of risk. You have emergency repairs, you have hazards posing a significant risk, which will be 7-day repairs, and then you will have others that are lesser and will still need to be addressed, but not within that fixed period. As is the case now, though, there's still no end date, backstop date for repair deadline, but it has to be that you don't unreasonably delay the completion of the work. So it takes into account the fact that it might be complex, it might not be capable of resolving really, really quickly, but you would need to evidence why there is a delay. And you also need to look at, actually, is this resident particularly vulnerable and do we need to escalate it quicker? Where there is an emergency issue, so a hazard that presents a significant and imminent risk of harm, that has to be treated really quickly. It has to be treated as an emergency, and in particular within 24 hours. So that would include things like gas leaks, boiler outages, having no water, particularly dangerous electrical issues. Now, initially my thought was actually there shouldn't really be too many serious emergencies involving damp and mold. There is an example given in the government guidance that suggests where there is prevalent damp and mold, and that could impact on the residents' ability to breathe. Obviously, there's going to be a bit of a case-by-case basis on this, and so we await to see what the guidance says about how damp and mold issues can be categorized as that sort of significant and imminent risk. In essence, though, where there are emergency issues and they can't be dealt with promptly, it's likely that the law is going to require that the RP decants the person, the tenants, and puts them somewhere safe at their own expense, particularly if it can't be addressed really quickly. It's going to be important to keep clear records. The law is likely to require that anyway, so that you can see when the clock started and when the timescales apply. But in addition, as an RP, you need to be able to demonstrate what you've done to try and comply with the law. So it might be, for example, you are doing all that you can to try and effect a repair, but for example, you can't gain access to a property. Because they won't be any tenants either not there or they won't let you in to investigate. And what's anticipated is that the regulations will say you need to make reasonable attempts. That will be supported by guidance. And the current thinking is that you agree time slots and you attempt at least 3 visits to try and resolve that. And then thereafter, obviously, it's not necessarily your fault that you haven't been able to do it, but you just need to be in a position to evidence that, document it, and demonstrate it. As soon as you do get into the property to investigate, then the timescales will kick in again. So once you've investigated, you still have 48 hours to then do a report and then 7 days to start it if there is a significant risk of harm. In addition, there may be situations where you just can't do the work in the time for whatever reason, and so you need to evidence what attempts you have made to comply with the timescale. So it might be that it requires a specialist contractor and you just can't get one, or you don't have sufficient materials. So that's what we're anticipating. What's the situation if you fail to comply? Well, a breach of Awaab's law, so the regulations that will come in, effectively it will give a right of action for breach of contract. And as I say, at the moment, that's only in relation to social housing tenancies, but it is likely to extend in due course to the private sector as well. And if successful, the court can order repairs are completed, can order compensation, payment of legal costs, and so on. But it doesn't impact on any other sources of redress that the resident may have. So the availability of a complaint to the housing ombudsman and so on, that still exists. There is the similar power under the Homes Fitness for Human Habitation Act. If you have concerns, effectively you can bring an action for breach of contract. My expectation is that actually they will lessen, because Awaab's law will provide a quicker, cleaner, and easier route to doing that. But in addition, if there are issues, concerns around the state of premises, of the property, there are other routes to enforcement. The local council can take action in relation to Category 1 hazards under the Housing Health and Safety Rating System. They can issue improvement and prohibition notices, or in very serious cases can undertake the remedial works themselves, and they can then claim the costs of that back from the landlord. Now, that's a power that has existed for a long period of time. That covers both the private and the social sector. And obviously, in the event that notices are issued and the landlord fails to comply with them, that can be escalated even further to the possibility of criminal action for failing to comply with the notices, or also the issue of civil penalty notices. And then, of course, there's also in the connection with the regulator of social housing, the Decent Home Standard, which they enforce. They have a wide range of powers against you as an RP. We could talk about that all day, but in essence, there is due to be, along with all of the other changes around housing, there is due to be a new Decent Home Standard published imminently as well. Now, one thing I talked about earlier was a bit of a trend, a developing trend really, of private action being brought in relation to damp, mould, and condensation matters. So this is action under the Environmental Protection Act, the EPA, and it sort of aligned with action that the council would have to address a statutory nuisance. So in essence, and this can happen in relation to commercial premises as well, but the Environmental Protection Act gives power to take legal action in relation to statutory nuisances. So for damp and mould matters, that can include domestic dwellings where they're in such a state, so there's such a deterioration in its condition as a result of damp and mould, that actually for the occupants that could be prejudicial to their health and therefore deemed a statutory nuisance. Now, the local authority environmental health officers, they can take power by issuing what's known as an abatement notice under Section 80 of the Act. And an abatement notice effectively directs what needs to be done by the housing authority, by the RP. and it will say this is what you need to do, and this is the date by which you have to do it. If you fail to comply, that is a criminal offence, and you're subject to an unlimited fine. But it's quite rare for abatement notices to be dealt with in the context of social housing or housing matters because there are many other routes to redress. However, there is a growing industry, a bit sort of no win, no fee type legal industry. Well, I don't like to criticize other lawyers, but it seems to be something that is developing whereby there are various claims companies who are jumping on the damp and mold bandwagon, and they are seeking to introduce private prosecutions to address statutory nuisance matters. So, under Section 82 of the Environmental Protection Act, anyone aggrieved by a statutory nuisance, which can include a tenant, can start proceedings in a magistrate's court to seek the court to grant an order, which is very similar to an abatement notice, asking that that nuisance is dealt with, so that the damp and mold is removed or cleaned, or if there are longer term issues that need to avoid it, that's rectified. But at the same time as the potential for making an order to rectify these issues, the magistrates also have the power to issue an unlimited fine. And that at the moment is seemingly due to a rare quirk in the legislation, sort of seemingly without actually a trial into the issue. So that's under Section 82(2) of the Environmental Protection Act. So if they make an order for you as an RP to abate a nuisance and you fail to comply with it, that is a criminal offence. But equally, there is this sort of strange quirk that sits there that says by the time they've actually got to the court, while they're thinking about making an order, they can also issue a fine, and that's criminal in nature. So, one thing to look out for is that before they can get to that, you have to be put on notice. Now, the wording I've put sort of into this slide, but in essence, you have to be given notice under Section 82(6) of the EPA, and you have to have 21 days. And it's 21 days of an intention to bring nuisance proceedings. So you need to act promptly if you get that. That's not a letter to be sort of shoved in a bottom drawer and ignored. Excuse me. So we're involved in a number of current cases where those bringing the prosecution are suggesting that even the absence of response to this letter exposes you to the possibility of a criminal fine. So it needs prompt action, and you need to address it. Okay, turning back to Awaab's law then, and obviously again it's a bit of crystal ball gazing, but there are some things that can be done now. What can you do to prepare? You've got 5-6 months before the first phase kicks in, and there are things that you need to be thinking about now. So one of them is capacity. In relation to addressing the timescales for investigation, for recording, for undertaking the works, should it be necessary, do you have enough internal resource to do that? Can you meet those timescales if you do, bearing in mind the volume of your housing stock? Do you have enough contractors that can support any internal teams for doing this? Do you have cover over weekends and bank holidays, bearing in mind that the timescales are calendar days? So it's not going to be enough just to have a Monday to Friday call hotline or something like that. If an emergency repair is required on a Friday night or Saturday morning, you've got until Sunday morning to address it. You can't therefore not have some form of weekend cover. Will you need additional contractors to come in? And in particular, if you have to deal with the onboarding via a procurement process, you know, how long is that going to take, and should you be starting that now? Record keeping, you'll need to have a look and check your procedures and protocols. Are they adequate? Are they properly resourced? What happens if you have a lot of issues all coming at once? Do you have anybody that's recording when these reports are being made of a hazard, a concern that needs addressing? But do you have anybody that's then diarising and chasing up and monitoring the key dates and the fact that you're actually complying with those timelines? And as I said earlier, do you have an emergency repairs procedure, which I imagine you do, and most RPs do, but is it adequate? Is it at the moment, does it cover the 24-hour period that you would need to do? Do you have enough trained staff to be in a position to record resident concerns and possibly deal with emergencies or any decanting process? And you might want to think about, well, do you need to sort of implement any training regimes or upskilling around competence for people to go out and either investigate matters or um, for for those that are taking reports and whether or not these are actually HHSRS hazards that fall within the proposed RWAB's law. I mentioned emergency repairs. Do you have a procedure? Is it sufficient? But obviously, one of the things that's quite important, particularly around damp and mold, is that, well, actually, that doesn't happen overnight. So, are there things that you can do that can actually prevent these issues from escalating to an emergency situation? So, are you conducting regular inspections or checks? Are you having sort of regular interactions and contact with your tenants? Something that will reduce the likelihood of an emergency scenario arising. Do you have policies explaining what the new requirements are that need to be followed by your staff? And if not, you might want to make sure that you've got one in place. Do you have a damp and mold specific policy? There's some very detailed government guidance which is already out in relation to damp and mold issues. The expectation is that that will be followed, and so any policy that you have should really be aligned to that. And if you do have policies and procedures now, have you reviewed them? Have you updated them to include how you're recording and reporting repairs, how you're monitoring progress, and how you're in a position to meet those deadlines? And then finally, do you know what the current condition of your housing portfolio is? Is it in good shape? Are there areas where there are particular points of concern? You're having increased level of damp and mold issues. Is there something that you can do now that's going to make it less of a problem moving forward? Do you undertake regular condition surveys? Have you got increased tenant engagement? Anything there that will sort of encourage or suggest particular early reporting of damp and mold before it becomes a significant risk of harm or even more serious than that? So, and finally, what changes and amendments might you need to make to any tenancy agreements or address access arrangements and stuff like that? So there are things that, irrespective of the actual fine print of what comes in, there are measures that you can be taking now to prepare. So there's probably a couple of minutes. I'm just going to see if there are any questions, and I can't see any, which is fine. But if you do have any questions, obviously we do need to wait and see what the actual law will say and the fine text of the regulations once they come out, and equally how helpful the government guidance is going to be in terms of advising on what constitutes a hazard with a significant risk of harm and so on. So, but should you need any assistance before then or once the law comes in, then obviously you've got our contact details, and please do not hesitate to get in touch. Thank you for listening. It's pretty much bang on half an hour. I've surprised myself, but feel free to contact me or any of the rest of the team if you have any follow-up queries or you'd like any advice around implementation. Thank you.